it is useful to preliminarily specify the perimeter within which we use the expression crowd investing. For crowd investing, I will not refer to every crowdfunding model, and in particular not to donation-based and reward-based crowdfunding, but only to crowdfunding services offered by online platforms that involve a potential financial return for the investors through the subscription of transferable securities issued by the fund seeker. This is the investment-based crowdfunding, bearing in mind that pursuant to European Union legislation, transferable securities can consist in shares in companies and other securities equivalent to shares in companies, partnerships, or other entities, and depository receipts in respect of shares, which is the equity crowdfunding, and bonds and other forms of securitized debts, or the entering into loan agreements, which is the lending-based crowdfunding. Currently, the crowd investing regulations in the single European Union member states can considerably diverge from each other, while there are some member states that have not regulated at all the crowd investing services through a specific legal framework and therefore consider the related activities under the MiFID II directive. Some countries, just to make a couple of examples, provide an authorization that allows crowdfunding portals to operate both as investment-based crowdfunding, so hosting public offers of shares and bonds, and as lending-based crowdfunding platforms. Some other countries, to the contrary, limit authorization to investment-based services or only to certain investment-based crowdfunding services, limiting the issuing of specific transferable securities, for example, only to equity crowdfunding, as it was in Italy until now. Another example of the fragmentation of the European Union legal framework relates to the upper limits of the threshold regarding the amount of the offers. The member states that provide exemptions from the obligation to publish a prospectus for the offers conducted through crowdfunding platforms shall specify the related threshold under which the exemption becomes applicable. And such threshold can consistently vary from country to country. In Italy, for example, the upper limit has been recently increased from 5 to 8 million euro per year. It is also worth mentioning that as the domestic regulations have normally been approved in exemption of MiFID II directive, and consequently, most of the portals are not authorized to operate under MiFID II, this entails that the portals authorized in single member states cannot passport their authorization to another EU country. This lack of harmonization causes undeniable problems for the platforms to provide their services cross-border within the European Union, and consequently to scale up their businesses due to their fragmented and sometimes conflicting national regulatory regimes. These difficulties regarding particular different licensing regimes, application of different thresholds and exemptions under the existing European Union legislation, different definitions of crowdfunding portals' business models, and different investor protection measures compared to similar risks. In order to resolve the problems due to the lack of harmonization, the European Union institutions are discussing a draft of regulation on European crowdfunding service providers, which is aimed at establishing a European label for investment and lending-based crowdfunding platforms and enabling cross-border activities. While waiting for the approval of such regulation, which is foreseen for May 2019, and its application, which is foreseen after circa 1 year from its approval, the European crowd investing portals will continue to face the above-mentioned problems to operate cross-border, and this would require compliance with different regulations. In any case, an overview of the domestic regulations on crowd investing shows that practically all member states that specifically regulated this phenomenon provide a set of minimum measures aimed at ensuring proper management and deposition of certain requirements and protecting the investors by focusing in particular on sound risk management and adequate information disclosure. In particular, the following legal and compliance issues have been taken into account by most of the member states. Conditions and procedures for authorization, in this case investment-based crowdfunding portals, can be authorized within the following models. Under the domestic laws implementing MiFID II, under an ad hoc MiFID II exempted regime, by being authorized for services and activities related to financial instruments not falling within MiFID II or outside the MiFID II framework. Such models are usually not exclusive and can normally be combined. In Italy, for example, platforms can decide to be authorized under Model 1 if the related requirements are met, or Model 2. In order to operate on the market and provide credit to consumers or credit brokerage services, the lending-based crowdfunding portals can be obliged to seek for specific license to carry out lending crowdfunding activities under bespoke regimes, or to have a general trade license requested for such activities by the domestic legislations. Then we have organizational requirements. Such requirements typically consist in client asset rules and record-keeping requirements, conflicts of interest procedures, as well as good repute, professionalism, and competence requirements of portals managers. Then we have the conduct of business obligations, which are, for example, the duty to carry out the appropriateness test in order to understand if the retail investors are appropriate for the investment they want to make, the need to conduct a due diligence on the offers, the obligation to disclose the predetermined criteria used for the selection of the projects, the duty to provide know your customer procedures and risk warnings on the platform. Moreover, in some member states, portals must also limit investment amounts on the basis of the categorization of investors, for example, retail or professional investors, natural persons or legal persons, etc. Then we have transparency requirements, which consist in particular in the obligation to provide investors information regarding the risks of the investment, typically illiquidity and risk of losing the entire amount, etc., as well as disclosure documents containing some key information regarding the fund seeker, the investment, and the project.